take. Court does call the case of People versus Richard Jefferson.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Jefferson. Mr. Jefferson, could you please state your name for the court?
Richard Jefferson.
Your Honor, we're going to be waiving the preliminary examination. There's been, we'll say, plea discussions going on right now, and they're not 100% there, but the baseline that we've worked out is that there'd be like a no MDOC sentence agreement, and with that, we're prepared to waive.
That is correct.
So the agreement is no MDOC sentence.
Yes.
That's as far
We're
as
discussing other parameters of the plea, but at this time we would agree to no MDOC.
all right. Mr. Jefferson, you're waiving your right to have a preliminary examination?
Yes, I am, Your Honor.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed?
Yes.
You understand that you'll not, by waiving, that you will not have that hearing, that you'll proceed to circuit court for further resolution?
Yes.
All right. People also, for the record, made their way.
Your Honor, we do an additional matter of right now, house of prosecuting attorney for the people.
Yeah, but it was going to, you know. I didn't mean it. I didn't mean it that way.
Your Honor, an additional matter, we want to make sure it's clear for the record that if for some reason it doesn't resolve in circuit, we wouldn't come back down here, we would then proceed to trial.
Right.
No argument with that. This is not like a conditional.
Yeah, I did not. Well, the only thing that might be a failure of it would be the MDOC sentence, at least at this point, right?
Correct. I mean, no one way we usually see that happen is if there's a violation.
All right. You understand that, sir?
Yes.
All right. Did you guys waive?
Did we just waive?
We do.
Oh, all right. Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Bernstein.
Your Honor, we ask the court to please waive any further reading. Ask the court to enter a not guilty plea.
Defendant waiving reading of the information. Pleading not guilty, court will enter that plea. Pretrial in this matter will be set.
December 3rd,
December 3rd, 2025, 1:30 before Judge Conlon.
And Your Honor, he did find himself in this currently incarcerated position as the result of bond violations that was adjourned to today as well. For what it's worth, he is prepared to admit to that at this point, those bond violations, and hopefully bend the court's ear regarding like a release to inpatient treatment type scenario.
So as to the violations of alcohol consumption and tampering, he would admit to those violations?
We're admitting to him, yes, Your Honor.
All right. Court will accept that admission. And what are you now asking?
We're hoping that the court would consider a release to inpatient treatment, residential treatment. You know, obviously when there's a violation like this, it spells out, you know, what's going on, and that help is needed, Your Honor. And so we're not asking for just straight release into the world, but if he's able to be released to an inpatient treatment facility.
Any response to?
Your Honor, you would object to inpatient at this time, but we would ask the court to do an order for him to do John Farms in jail and start that treatment for alcohol. And at that time, see how he does. And then hopefully we get a resolution at first pre-trial. Maybe inpatient treatment after that.
All right, what I will do is, how long has he been in?
The PCC date, 2 weeks ago, yeah.
So he's been in 14 days. All right. So what I will do is I'll sentence the defendant this way. Sentence the defendant to 90 days, credit for 14 that he served, will indicate defendant is to complete the non-firms in jail program. And then if completed, consider early release from this sentence. And I say that, but all of that certainly at this point is going to be up to Judge Conlon in terms of how he wishes to handle it. All right. Okay.
Your
At
Honor.
this point, his bond will continue. Thank you. Wow. Okay.
Number 3rd. Number 4th for you, so we'll be there.
Depends on which word you want. Yeah,
Now that the courtroom is wrapped for the day, let's break down the bigger picture here. Because what just happened is far more layered than it might appear at first glance. Richard Jefferson walked into this hearing facing two major crossroads: the future of his felony case and the consequences of his bond violations. And in just a few minutes, you watch both issues collide in a high-stakes negotiation between the defense, prosecutor, and judge. First, let's recap the waiver of the preliminary examination. When Jefferson agreed to waive that hearing, he essentially skipped the step where the prosecution would normally need to prove probable cause. Why does that matter? Because it signals something important. Both sides are trying to move quickly toward a plea deal. And the centerpiece of that deal, the absolute non-negotiable line in the sand, is that Jefferson does not want an MDOC prison sentence. Defense made that clear. The judge acknowledged it, and both sides agreed that the only thing that could derail these negotiations is whether MDOT time becomes unavoidable. That's a huge indicator of where the stakes truly lie. But it was the second part, the bond violation section, that injected a surge of drama into the room. Jefferson admitted to alcohol, use, and tampering to violations that judges take extremely seriously because they signal a disregard for court orders. Yet, instead of denying responsibility, the defense leaned into accountability, arguing that these violations actually highlight Jefferson's need for structured inpatient treatment, not punishment. On the other side, the prosecutor pushed back, strongly insisting that Jefferson needed to start in the arms and jail program before any discussion of inpatient treatment could even be considered. Two very different philosophies collided here: rehabilitation versus structured correction. Then there's the judge's final ruling. 90 days with credit for 14 already served and a potential early release if Jefferson completes arms successfully. This was a measured, strategic decision. The judge balanced accountability, community safety, and treatment needs all at once. It wasn't purely punitive, nor was it purely lenient. It was a structured path. Prove yourself in the program. Earn the opportunity for earlier freedom, and then continue the case in front of Judge Conlon. But here's the real question for all of you watching. Do you think the judge made the right call? Should Jefferson have been given immediate access to inpatient treatment like the defense wanted? Or was the prosecutor correct that he needed to start by earning trust inside the structured jail program first? These decisions can shape a defendant's entire trajectory, sometimes even their long-term recovery. As this case moves forward to December, all eyes will be on whether Jefferson can follow through. Early release is on the table, but only if he puts in the work. And when it comes to sentencing, Judge Conlon will have the final say. The tension isn't over. It's just shifting to a new courtroom. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.